Two veterans challenged VA rating reductions. In one decision, the board restored a 100% mental health rating. In the other, the board upheld a reduction from 70% to 50%. Same basic issue, opposite result. The difference was not simply whether VA is allowed to reduce a rating, it was what VA had to establish, which protections applied, and what the record showed about improvement in ordinary life and work. This is the VA claim file from Claim Raven. We are going to put both official decisions side by side, then build a practical way to read a proposed or completed reduction. One important limit before we start. Board decisions are not precedent for other veterans. These are real, source-checked illustrations. They are not predictions about your case. You have probably heard some version of this warning. Filing for an increase can put an existing rating at risk. That warning may get attention, but by itself it does not help you understand a reduction. The more useful question has 5 parts. Was the required procedure followed? Was the rating total? How long had it been in effect? Were the comparison examinations complete and reliable? And did the evidence show an actual improvement in the veteran's ability to function under ordinary conditions of life and work? Start with procedure. Under 38 CFR Section 3.105, when a proposed evaluation reduction would reduce compensation currently being paid, VA generally has to prepare a proposal explaining the material facts and reasons. The veteran gets 60 days to submit evidence showing that payment should remain at the current level. The notice also provides an opportunity to request a predetermination hearing within 30 days. If that request is timely, the existing payment level continues while VA makes the final determination. Those timing rules matter, but procedure is only one part of the file. Next, ask whether the rating is total. Under 38 CFR Section 3.343, a total disability rating generally is not reduced without an examination showing material improvement. VA has to consider that examination with the rest of the record and pay particular attention to whether the improvement happened under ordinary conditions of life, including work. Then ask how long the rating stayed at the same level. Under 38 CFR Section 3.344, ratings in effect for 5 years or more receive added stabilization protections. VA is supposed to review the full examination and medical history. A less complete examination should not become the basis for reduction. For conditions that can temporarily or episodically improve, one better-looking examination generally is not enough unless the full record clearly shows sustained improvement. For a rating under 5 years, those specific stabilization provisions do not apply in the same way. But that does not mean VA can reduce the rating without showing a real change. The comparison still has to address the disability history, the quality of the examinations, and improvement in ordinary life and work. Now look at the first decision, A2504348. VA granted a 100% rating for schizoaffective disorder effective in April 2013. VA later proposed a reduction in June 2021 and issued the final reduction in November 2021, effective February 2022. That rating had remained in effect for more than 5 years. The board therefore applied the stabilization protections in Section 3.344. The board reviewed the examinations and did not find sustained material improvement. The record still showed serious symptoms, continuing psychiatric treatment and medication, and difficulties affecting work and daily functioning. Some findings had become worse, not better. The key distinction is that VA had focused on whether the veteran's current symptoms appeared to match the 100% rating criteria. The board explained that a current percentage comparison by itself was not the correct reduction analysis. The question was whether the evidence demonstrated sustained material improvement under ordinary life and work. The board found that it did not, so the 100% rating was restored. Now compare decision A250-21682. This veteran had a 70% rating for a psychiatric disability from May 2020 until the reduction became effective in May 2024. That was less than 5 years. VA proposed the reduction in May 2023. The veteran requested a hearing. A predetermination hearing was held, and VA obtained another examination from a different examiner before issuing the final decision. The board found that the notice, hearing process, and effective date timing met the applicable procedural requirements. It then reviewed the earlier and later examinations along with treatment and functioning evidence. The board found actual improvement, including improvement in ordinary life and work. The record discussed independent daily functioning, education and work activity, treatment progress, and changes across the comparison examinations. Because the rating had been in effect for less than 5 years, the added stabilization rules in Section 3.344, subsections A and B, did not apply. But the board still examined whether there was a real change and whether that change improved the veteran's ability to function. In that record, the board found that standard satisfied. It upheld the reduction from 70% to 50%. Put the decisions side by side and the lesson becomes clearer. The first case does not mean a 100% rating can never be reduced. The second does not mean a rating under 5 years is unprotected. And neither decision proves that filing for an increase automatically causes a reduction. The real distinction is the full chain: procedure, rating status and duration, examination quality, actual change, and functioning under ordinary life and work. If you are trying to understand a reduction, build a 4-part file before jumping to a conclusion. First, write down when the rating began and every date it was continued. That tells you how long the same evaluation had been in effect and whether total rating or stabilization rules may need closer review. Second, collect the proposal, notice date, hearing request, hearing record, final decision, and effective date. Build the timeline instead of relying on memory. Third, put the examination that supported the original or continued rating next to the examination used for the reduction. Look at what each examiner reviewed, what each examination measured, and whether the comparison is actually complete. Fourth, identify evidence about ordinary life and work across the same period. That can include treatment history and documented changes in daily functioning. The point is not to manufacture a story. It is to see whether the record supports the improvement VA says occurred. Claim Raven can help organize that source trail and verify whether a cited statement is supported by the document. It cannot decide whether a reduction is valid, choose a review lane for you, or predict what VA will do. That is how these two real decisions reached opposite outcomes. A rating reduction is not just a new percentage lookup. It is a comparison over time, governed by procedure, protection rules, examination evidence, and real-world functioning. If you want more source-checked VA decisions explained this way, subscribe to Claim Raven. The official regulations and both board decisions are linked below.